Just testing my sound. Can you hear me? Testing my sound. Can anybody hear me?
Yes, I can hear you.
Thank you.
Sure.
Good morning, everyone. Before I officially call our hearing, let me just check in with my court reporter. Harriet, are you there and are you ready?
I'm ready. Thank you.
All right, thank you. Now calling proceeding number 23A-0356E. This is day 2 of an evidentiary hearing in this proceeding concerning Public Service Company of Colorado's application for an order authorizing it to modify and extend its electric quality of service plan through 2026. This hearing was scheduled by decision numbers R23-0617-I and R24-0200-I. It is April 3rd, 9:00 a.m. My name is Melody Mirbaba. I am the administrative law judge who is assigned to hear this case. And consistent with commission practice, we are webcasting this hearing, we are recording this hearing, and we have a court reporter taking down everything that's being said. So with that, why don't we go ahead and start with entries of appearance. I want to hear from Public Service first.
Good morning, Your Honor. On behalf of Public Service Company of Colorado, Stephen H. Denman and Emily Giraldo.
Thank you. From the Colorado Public Utilities Commission trial staff.
Good morning, Your Honor. Brian Krakis from the Attorney General's office on behalf of trial staff.
Thank you. On behalf of the Colorado Energy Consumers. We'll go back to the Colorado Energy Consumers. On behalf of the City of Boulder.
Hello again, Your Honor. This is Andy Ball on behalf of Boulder with the law firm of Keys and Fox.
On behalf of the City and County of Denver.
Good morning, Your Honor. Amanda MacDonald from the Denver City Attorney's Office on behalf of City and County of Denver.
On behalf of Energy Outreach Colorado.
Good morning, Your Honor. Daniel Rubin with the law firm Dietza and Davis on behalf of EOC.
Okay. On behalf of the Utility Consumer Advocate.
Good morning, Your Honor. Kate Crampton with the Attorney General's Office on behalf of UCA. I'm joined as well by my colleague Patrick Wittersheen.
Okay. Now let's go back to the Colorado Energy Consumers. I see counsel's with us now.
Thank you, and my apologies. I had some computer issues this morning. So Michelle King on behalf of the Colorado Energy Consumers.
Okay, thank you, everyone. So we convened today primarily because I wanted to see a proposed tariff from the settling parties that would be consistent with the settlement agreement. And I believe that has been prepared. I'd like to just check in with Counsel for Public Service on that.
And Ms. Giraldo will discuss the tariff with you, Your Honor.
Thank you.
Good morning, Judge Mirbaba. Sorry, I was hearing myself echo. But yesterday afternoon, I sent you a copy of our proposed compliance tariff, and I copied all other parties, and this is agreed upon by the settling parties, but we have not yet gotten feedback from EOC and UCA, the parties that did not join in the settlement agreement, and we have that on box.com and ready for us to seek to admit that into the record. It's marked as hearing exhibit 110. And the way that it is formatted is it's a red line that reflects changes compared to our originally proposed QSP tariff, which was attached to Jason Piquet's direct testimony, which I believe was JJP1 and JJP2, those attachments. And so that's the format that it currently is. But I would flag that it's not red lines comparing our currently applicable tariff and the new QSP. It's just showing the changes from our direct case and what we're proposing here through the settlement.
Okay, thanks. That's what it looked like to me as well. Thank you for going to the effort of putting that together and sharing that among the settling parties. I do want to check in with EOC and the UCA specifically about before this exhibit is offered into evidence, number one, whether you see a need to examine any witnesses about this exhibit, or frankly, if you have any objection to the admission of it. And we're looking at, I believe it's hearing, is it hearing exhibit 110? Is that what it is?
Yes.
Okay. Why don't we start with EOC?
I was hoping we'd start with UCA. I have not had the opportunity to review the tariff sheet, so maybe it would make sense to start with UCA. Maybe I didn't get it, but if it was sent yesterday afternoon, then I guess I missed it.
Oh, apologies. Yeah, I know we sent it to the attorneys that had entered their appearance before, so Gabriella and Mark, so maybe you were left off that distribution. I apologize. I'll forward that to you now.
And we can also pull it up on the screen, but it might be easier for you to have it on your computer. So why don't we come back to EOC? Let me turn to the UCA.
Yes, thank you. UCA has had an opportunity to review it. We do not expect to have any need for examination of a witness. We are intending to object and make a record when the company seeks to introduce it. So we were just planning to handle our concerns in that manner.
Okay, all right. Certainly, if there is a stipulation about the admission of an exhibit, we typically don't call a witness to testify about it. But Ms. Crampton, are you saying you want to object to the admission of the exhibit, or something else? Because if you do want to object to the admission, then I do think we need to proceed in the normal fashion and have a witness testify about the exhibit, and then you could lodge your objection then.
I understand what the court's saying. I mean, I can just preview. Our objection is consistent with our objection to the settlement agreement. We also have some objections based on the content of what is in this red line document as being inconsistent with the settlement agreement. So I was just intending to make an oral objection, not examine a witness, but I understand what the court's saying about laying the foundation with a witness. So that's how we intended to handle it. I'm not sure if that changes anything for the court.
Well, Your Honor, I might help here. The purpose of this exhibit, as I understand it, is that Your Honor wanted a tariff that reflected the terms of the settlement agreement, and Public Service Company believes that it did. Counsel has made that representation to you, plus all the settling parties have reviewed it, and they agree that it reflects the settlement agreement. And it seems to me that counsel for UCA's objection will go not to the admissibility, but to the weight. And if there's something they believe is inconsistent with the settlement agreement, it would be helpful to hear that, to simply so that if we need to make revisions, or Your Honor wants something else in there, we can handle that. But I think this is not an issue of admissibility of the exhibit. It's an issue of the weight and perhaps content. Of course, we expected that UCA would object to the tariff because they object to a couple of parts of the settlement. But then, as Dr. Ingram testified yesterday, there are a number of components of the settlement to which the UCA does not object. So, I don't know if that's helpful or not, but I hope it is.
Yeah, I think Mr. Denman has summed it up well, in that it sounded a lot like Ms. Crampton. The UCA's objections aren't related to admission of the exhibit, but substance of the exhibit. So you don't, I really want to get at whether you're going to object to the admissibility. I have to say, based on your comments, it sounds like we probably are going to need a witness, because if the UCA has identified things in the proposed tariff that are not consistent with the settlement agreement, I think that has to probably come through via evidence and a witness. But I do think that that is a separate question from whether there's an admissibility objection to hearing exhibit 110. At this point, I'm thinking it just makes sense to move forward with having a witness testify, and then we could just see how things play out. And Ms. Crampton, you can ask questions of that witness to identify any issues substantively that you think would contradict or not consistent with the settlement agreement in that manner. Does that make sense?
Yep, that's fine. And I think the examination will be fairly brief.
Okay.
Your Honor, that's also fine. Public Service Company is prepared to present a witness to authenticate and sponsor the tariff.
Okay. So I also just want to preview something. I'm trying to determine when is the best timing for this, either before or after the witness. So I'll throw this out there for the parties to consider and let me know your thoughts. What would be helpful for me to have pretty clearly in the record as a factual stipulation from the settling parties, if they do agree to these three things, which are: number one, that the proposed tariff, which is hearing exhibit 110, is consistent with and implements the settlement agreement. Number two, that to the extent that proposed tariff, hearing exhibit 110, modifies or clarifies anything in the settlement agreement, that the settling parties agree to those changes. And that would include where the proposed tariff defines terms that are in the settlement agreement but are undefined in the settlement agreement. And then three, that to the extent the proposed tariff, hearing exhibit 110, continues or maintains any aspect of the existing QSP, that the settling parties agree to this. So the question is this something you all would prefer to have addressed after we hear testimony, particularly in light of the UCA stating that there may be inconsistencies between this tariff and the settlement agreement? Or is this something we can address now? I'll start with staff.
I think staff's preference would be to address that after we hear testimony, Your Honor.
Okay. Does anybody else have a position you want to express? Any of the other settling parties?
I think it would be fine to address those matters after testimony is heard. Okay,
then let's do that. And I also just want to again say thank you for putting that together. I did take a look. I think it's hopefully going to be helpful for our record. So Mr. Denman, why don't you go ahead and call your witness?
I'll turn this over to Mr. Aldo. Thank you.
Okay, thank you.
We started with Jason.
Jason.
Public Service calls company witness Jason Piquet to the stand.
Hi there, Ms. Piquet, Mr. Piquet. Sorry about that. I'm not going to re-swear you in. You were sworn in yesterday, and I'll just remind you that you're still under oath and that the same advisements I gave you yesterday also apply today. Go ahead and state and spell your name for us one more time.
My name is Jason Piquet, Jason Peuquet.
Okay, witness is yours.
Great. Mr. Piquet, we introduced you at the hearing yesterday, and today we've filed this proposed compliance tariff as hearing exhibit 110. Have you had a chance to review that draft compliance tariff?
Yes, I have.
And do you agree that it reflects the settlement agreement, that it accurately reflects the settlement agreement?
Yes, it does.
Is there anything that you were hoping to clarify concerning that hearing exhibit, or do you think we can proceed to cross-examination on it?
Yep, we're ready to proceed.
Okay, that sounds good. Because I know there were a couple of items that maybe didn't quite get into the red lines.
Yes. Yes, thank you. Happy to talk about that now if that's helpful for the court. So there were two numbers that were changed as part of this tariff that were not track changed for presumably just a strange formatting hiccup. So I'm not sure which page it's on, but where we're talking about the maximum penalties, I believe it was on page 3.
Let's get that document opened and on the screen for everybody.
Yes, and do we have Ms. Kunkel today helping us?
I think so. Stephanie?
Yes. Yes. Thanks.
Okay, great. Yes, Ms. Kunkel, if you could please scroll down to page 3, that would be greatly appreciated.
And just for the record, we're looking at hearing exhibit 110, which has not been admitted yet.
Right. So I know it was somewhere where we talked about 1.1
Yeah, you might
million.
from the top again, just so we can scroll down and find exactly where it was. Sorry, it looks like it's not on page 3.
Or I don't know if you can control F that kind of a PDF or not, but there were a couple of 1.1 millions that were originally 1 million, but they were adjusted for inflation to 1.1 million, and for some reason that change just didn't make it into the red lines, correct, Mr. Piquet?
That's correct.
But it does appear in the proposed tariff. I think it's further down. We talk about penalty caps, so.
It's on page 2.
Oh, two. Okay, never mind. So it is further up. Oh yes, see, there were two 1.1 million for customer complaints and telephone response time. Is that what you're referring to, Mr. Piquet, that those changes should have been tracked? It should have, the additional 0.1 million should have been tracked for each of those, but for whatever reason, track changes wasn't turned on.
That is correct. And so we're not changing any content here. We're simply just noting that the two 1.1 millions right above the 7.73 million at the bottom of the screen should be highlighted in red as well.
Great, thank you, Mr. Piquet. And with that, he's ready for cross-examination and ALJ questioning.
Well, maybe do you want to go ahead and offer hearing
Oh, yes.
into evidence?
Yes, Public Service would request to admit hearing exhibit 110 into the evidentiary record.
Okay, any objections to the admission of hearing exhibit 110? Hearing exhibit 110 is admitted into evidence.
Great, and with that, Mr. Piquet is available for questions.
Okay, so I'd like to turn to the UCA. If you want to go ahead and if you've got questions for this witness, feel free. And it should be limited to matters that relate to hearing exhibit 110, which obviously does include settlement agreement as well and how it's represented in hearing exhibit 110.
Understood. Thank you. If we could pull up hearing exhibit 110, I think it'll probably just be easier to ask these questions going page by page. And thank you. And I have it, I'm operating off of the pages that are on the document, like the 131A, rather than the page numbers. So if we could go to page 131G, which I think is towards the end of the document.
If you can also identify the page number, that would help in navigating.
Sure. Okay, and so 131G appears to be page 8. And so Mr. Piquet, going down to the language concerning, let me just make sure I'm not looking at the same thing. Okay, Mr. Piquet, do you see the middle of this page 8, the paragraph that says Sealy-bill credit?
Yes.
Okay, and what the tariff language says is that all customers that experience a sustained electrical service interruptions of greater than 18 hours in duration shall be provided a bill credit. Is that right?
Yes, that's what it says here.
Okay. And you're familiar with the settlement agreement, which is hearing exhibit 105 attachment A?
Yes, I believe that's the hearing exhibit number.
Okay. And what the settlement agreement says is that for this Sealy calculation is that if a customer experiences an interruption of 18 hours or more in a given performance year, the company will award the customer a $55 individual bill credit. Is that right?
That sounds correct, but it would be nice to pull up that hearing exhibit
Sure.
number so we could all confirm that.
Okay, and before we do that, just to confirm on this hearing exhibit 110, this awards a bill credit for interruptions greater than 18 hours is the way this reads.
Yes, it reads that way.
Okay, thank you. And then if we could pull up hearing exhibit 105 attachment A and go to the bottom of page 4, please. Okay, and Mr. PK, do you see this language regarding Sealy?
I do, yes. It says an interruption of 18 or more hours.
Okay, and so the settlement agreement includes 18 hours for a bill credit, correct?
Correct.
Okay. And by contrast, the tariff language currently does not include 18 hours.
That is correct. That was a typo. So thank you for pointing that out.
Okay, no problem. And the settlement agreement is the intended outages that would receive a bill credit, right?
Yes, the settlement agreement is the operating document here. The tariff is simply trying to reflect those changes. And so we'll be sure to make an adjustment there.
Okay, thank you. If we could go back to hearing exhibit 110 and if we could go to page 131E, which is appearing as page 6. I apologize, that does not, oh, here. Mr. PK, I just want to walk through this public damage interruption criteria. The second sentence starts including vandalism or states including vandalism, war, or terrorism interruptions that are precipitated either directly or in response to an act of vandalism, act of war, or act of terrorism. I guess I'm trying to clarify, is that the complete sentence or is there language missing from that sentence? Or let me ask this question, is that the complete sentence intended?
Yeah, one moment. I'm just reading the sentence. That does seem like it's the complete sentence. It would probably read better as part of the initial first sentence in that subsection. I do not believe that is we haven't track changed any items in this paragraph from our original attachments JJP1 and JJP2. So if it's comment about the grammar, I agree with you. It's not the clearest, but I don't think we're missing anything there.
Okay. And then, some of these, I guess I would characterize more as housekeeping questions about the content, this being one of them. But if we could go to page 131D, which is page 5. And just this top paragraph with the IEEE, would the company agree that IEEE is not defined in this tariff?
I do not believe it's defined in this section of the tariff. I'm not sure if it's defined elsewhere in the company's electric tariff.
Okay. And if we could go to page 131B, please. And thank you. And this is page 3 of the document for the record. Mr. PK, I'm looking at the language of reporting requirements. And would you agree that this language regarding reporting requirements doesn't include all of the reporting requirements that are the actual requirements that are detailed in the settlement agreement?
That is correct. This is the company's tariff, which is an overarching summary of the company's QSP and details the mechanics of how we would implement that QSP. The actual details are left to those individual proceedings, like the one we're in here today.
Okay. And then, Mr. PK, I think probably if we could go to page, I think it would be page 2. Thank you. And you would agree with me that the tariff itself doesn't include any language about the settlement agreement term that states that there will be an inflation adjustment as measured by CPI-U moving forward for each subsequent QSP. Is that correct?
That's correct. We have not incorporated that statement into the company's tariff.
Okay, and so put differently, nowhere in this tariff language is there an indication that an inflation adjustment will be implemented moving forward.
That is a detail left to the individual QSP plans, not something that we brought into the tariff itself.
Okay, thank you. Those are all my questions.
Thank you. I just wanted to kind of ask.
Wait.
Sorry.
I need to see if the other non-settling party, EOC, has any questions about this tariff first.
No, Your Honor, and I have had a chance to review it now and have no questions.
Okay. Counsel, I'll go ahead and allow you to do redirect. I might have some questions after that. I'm kind of thinking you're probably going to ask every question that I would anyway. So we might be able to eliminate the need for me to do that. So why don't you go ahead and do your redirect? And if I have questions after that, I will, and I will give you one more opportunity if that's the case.
Sure. Mr. Piquet, for clarity, that discrepancy that Ms. Crimpton identified between the greater than 18 and the 18 or greater in the actual settlement agreement, would Public Service correct that in its compliance advice letter filing?
Yes, certainly. Before we actually made these tariffs effective, we would make sure that that compliance advice letter making these tariff changes reflected all final details from the settlement agreement and from the commission's final order.
And would the company also add in a definition for the acronym IEEE?
Yes, we'd be happy to do so.
And then to the other, with that sentence starting with the word including, that's kind of a sentence fragment in the public damages criteria. Would you agree that since that typo wasn't redlined, that it would have been present in the initial tariff kind of presented with direct?
Correct. And I do not believe that paragraph changed as a result of our filing in this proceeding. So that is likely language that's been longstanding. However, we're happy to fix the grammar there.
Would you agree that we would probably just make it part of the prior sentence and just have a comma before the word including, which would be lowercase n? or the word including
Either-
would be in the lowercase.
Either a comma or an M dash. But this is probably the first time I've been discussing grammar on the record.
No, that's definitely fair. And I know we don't have it pulled up right now. And would you agree that generally when we have commission approved, regulated programs or plans, that usually not all of the details of those programs or plans would be reflected in the tariff?
That's correct. There's a balance to strike here between having tariffs give the overarching summary of a certain plan and how the mechanics of that plan will propagate through towards customer rates, either charges or credits. And so we try to strike that balance in all of our programs. If you think about all the companies' programs affecting our electric customers, thinking about transportation electrification plans, demand side management plans, clean heat plans moving forward. If we included all those details in our tariff, the tariff would be extremely long, even longer than it is today. And so we try to strike that balance.
Would you agree that an incredibly lengthy and detailed tariff could result in customer confusion? And so that there would be a concern about that in terms of transparency. And
that's absolutely a concern that the company has. And again, we try to bring in the relevant details at a high level, and the actual final details can be seen in other proceedings, filings, annual reports, all the above.
And would you agree that this proposed tariff only applies to this QSP extension? So any inflation adjustments would be incorporated in the proposed tariff for future QSPs?
Yes, the company abides by its settlement agreements that it makes with other parties and that the commission approves in the instances where the commission does approve of them. And so we would certainly follow that provision if approved.
Great. And I don't think I have any further questions on redirect. So we can turn him back to you, Judge Mirbaba.
You covered everything, so.
Okay, great.
Found one minor efficiency today. Okay, so I think that really should end your testimony. Thank you for being available and for testifying again today. And at this point, unless the company has any other rebuttal evidence to present, that would end evidentiary presentations. Mr. Denman?
Your Honor, our rebuttal that was filed in this case was admitted yesterday.
Oh, yes.
So
yes.
we believe that we've covered all the bases and do not need to present further testimony for you today.
Great, thank you. On my housekeeping matters here before we conclude our hearing, I'm going to go ahead and admit hearing exhibit 900, which is just the PDF version of the linked spreadsheet that we have been using throughout the course of this hearing, and that identifies exhibits that were admitted by administrative notice as they appear in the record, the administrative record. Is there any objection to the admission into evidence of hearing exhibit 900?
No, Your Honor.
All right, I am going to take everybody else's silence to mean there is no objection to the admission into evidence of hearing exhibit 900, and hearing exhibit 900 is admitted. So I, in this case, decided to try something different and ask the parties to present proposed recommended decisions in lieu of statements of position. I do want to talk about that for a moment, but actually I'm thinking maybe before we go there, I can turn back to the settling parties to see if there is going to be a factual stipulation on the items identified earlier, and I can go over those with a couple of caveats, and that would be would the settling parties stipulate and agree that the proposed tariff is consistent with and implements the settlement agreement as with the changes that were discussed during Mr. Picot's direct examination just now? And does the settling parties agree that to the extent that the tariff modifies or clarifies anything in the settlement agreement, including defining terms in the settlement agreement, that the settling parties agree to those changes, and that to the extent that the proposed tariff, which is still hearing exhibit 110, continues to or maintains any aspect of the existing QSP, that the settling parties agree to this? Like to check in with staff.
Yeah, so Your Honor, I think we can stipulate to the first with the caveat that we'd like to see the change, particularly on the Sealy 18 hours or more discussed by Mr. Piquet. As for the second, as Mr. Piquet said, I mean, the operative document here should be the settlement, not the proposed tariff. So I would be hesitant to stipulate that any changes in the proposed tariff that we had 1 hour to review yesterday can modify the settlement. If we find anything else inconsistent before the company makes its compliance filing, we would want that also to be corrected. On the third point, staff, though, can stipulate.
Okay. Yeah, and I think that there might be in the tariff, hearing exhibit 110, some definitions that may not necessarily be clear in or even exist in the settlement agreement. So that was sort of a thing that I was interested in hearing.
Yeah, I think from staff standpoint, I mean, the larger point would be in the event we discover any other inconsistencies between the tariff and the settlement agreement, we would want the settlement to govern, not the tariff.
Gotcha. Okay. All right. Now let me check in with CEC.
Thank you, Your Honor. For CEC's part, the key issues that we were concerned with in this proceeding that are memorialized in the settlement agreement are not in the tariff, and they are found in the stakeholder engagement section of the settlement agreement. We don't have any concerns with what is in the tariff, but like Mr. Krikis said, we don't want the omission of elements from the settlement agreement, the omission in the tariff, to mean that we're waiving those issues. We negotiated in good faith and are pleased with the outcome as reflected in the settlement agreement on those points.
Okay, thank you. So CEC would agree that the proposed tariff, hearing exhibit 110, is consistent with and implements the settlement agreement, at least to the degree that CEC believes is necessary.
It wasn't CEC's position that the terms of the commitments in the stakeholder engagement that are not, implemented in a lasting way, but are implemented in accordance with how they're presented, namely between now and the next QSP. And so it wasn't critical to us that they be memorialized in the tariff, but if we would like to have all of the elements of the settlement in the tariff, then yes, those pieces need to be in there.
Okay. Let's turn to the City of Boulder. Same questions.
Thank you, Your Honor. Like CEC, Boulder's sort of core issues are issues that were that are primarily addressed in the settlement agreement and not the tariff. That being said, Boulder is willing to stipulate that the proposed tariff is consistent with the settlement agreement as adjusted by the company's direct testimony a few moments ago. From our perspective, the issues that are in the settlement agreement but not the tariff, such as quality of service mapping commitments from the company and other stakeholder engagement issues from the company, are, I think, appropriately addressed by the settlement agreement, and Boulder would expect that the company would sort of proceed in future QSP proceedings in line with the commitments it made in the settlement agreement, regardless of whether those commitments are outlined in the tariff.
Okay, thank you. And I'll just say, I don't think that every detail of the settlement agreement has to be in the tariff in order for the tariff to be consistent with the settlement agreement. And I think this tariff has about the same level of detail that a lot of other tariffs implementing similar programs would have. All right, let me turn to the City and County of Denver.
Good morning, Your Honor. I think I'll probably just do a lot of repetition to everyone else's points. As to number one, I think in line with Mr. Kreikes and with City of Boulder, I think similarly, we think hearing Exhibit 110, the proposed tariff is consistent with the settlement agreement. As we've discussed, not every term is reflected in that for the reasons that Mr. Piquet testified to. And we are comfortable with the changes that we have discussed here. As Mr. Kreikes had indicated, we would also like to see the ultimate red line version with those changes discussed, but as reflected during testimony, we are comfortable with those. As to number two, about if the tariff modifies a term, I think a similar position in that we had a pretty short time frame to really go through line by line of everything. So, prior to the company doing their compliance filing, if we were to find an additional edit, we would, want to have the opportunity to bring that up, but we take the position, I think, like everyone else has said, that the settling agreement, we expect the company to abide by the terms of the settlement agreement, and that is the controlling document if it is approved by Your Honor. And then as to number three, we will stipulate to that.
All right, thank you. I think I've covered all the settling parties. Is there anything anybody else would like to raise that's relevant to hearing Exhibit 110 and the tariff issues we were just discussing?
Yes, Your Honor, public service is prepared. We can update the tariff in line with our discussion today and circulate that among the settling parties and, as desired, file an updated version of that. I don't know whether it would be another hearing exhibit or whether it would just be kind of part of a notice to just for transparency reasons. I don't know what makes more sense to you procedurally, but we're happy to do that just for clarity.
I think we've got enough in the record about what would be changed, and it's pretty minor. So I think that's clearly, and I'm a little concerned that I don't want to have something else filed that could be viewed as evidence and it being brought into the record after the evidentiary record has been closed. It's one of the reasons why I tried to do it the way that we did it today. And I can understand that there was a short turnaround on putting that together, and think any of the typos and errors have been identified as it is. And I can say part of what I'm going to be doing when I issue my recommended decision is look at that. And if I identify something else, it'll certainly be in my decision. I would expect that before anything is ultimately implemented, that the company is going to have to make a tariff change in filing eventually, and that the parties will have an opportunity to look at it then as well.
Sure, we'll make sure we confer on it before any compliance advice letter with the parties.
Okay, so I had sort of started talking about proposed recommended decisions. So let me just go back to that. I'm viewing your proposed recommended decisions as just a different way for the parties to present their positions and arguments. But I do hope to see findings and conclusions supported with record and evidentiary citations, and I would hope to also see the parties address each contested and non-contested issues with record citations supporting the findings and conclusions related to those. And again, I am going to treat those as arguments, as the parties' arguments and as the parties' positions. So if settling parties file a joint proposed recommended decision, I will treat it as all of the settling parties' position in this case. All right, with that, I just want to check in and see, is there anything else that we need to address before we conclude our hearing?
I apologize if I've missed it, Your Honor. What's the due date for those recommended decisions?
I meant to remind everybody of that. My notes indicate that's due on April 22nd. Is that a date that is still good for the parties? Is anybody requesting more time? Right, I'll take that silence to mean we are all still good with April 22nd, so I'll expect to see those on the 22nd. Is there anything else we need to address?
Your Honor, Public Service has nothing further this morning.
Okay, thank you. All right, it does not appear that anybody else has any other issue to address. I want to thank you all for your presentations. You all did a fine job. I will be issuing a written recommended decision in due course. We are now adjourned.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.